In just a few days, on the 1st of September 2022, China's measures for the security assessment for a cross-border data transfer come into effect. Do you need to have a security assessment? And if so, what do you have to do? I'm here to tell you. Hello there, and how are you doing? Hope you are well. Here in Hong Kong, it is still too hot, but I think that's true of lots of places in the world right now. But also, we're still dealing with COVID restrictions, which still seems to be quite frustrating. To the point that I'm actually be going out of Hong Kong for a little while soon. I will be travelling. In fact, you can't see it because I've managed to organise it all out of frame, but there are electronic devices all around this room, all being updated, having data added to them. So I've got my music player. I still use a dedicated music player, by the way. I have my games console. Of course, I have an iPad and my laptop, you name it, all to be travelling wherever it is I happen to be going. So you could say that I'm doing a lot of cross-border data transferring. Thankfully, none of the data that I am transferring, as far as I'm aware, relates to China and Chinese individuals. If it did, then I may find myself subject to a security assessment. Because you will remember, if you don't, then I can show you on my previous videos, I'll link to at the end of this. China brought into force 3 data laws: a cybersecurity law, a data security law, and a personal information protection law. Cybersecurity law was pretty much dealing with critical infrastructure and national security. Data security law was really data that affects national security more than anything else. And the PIPL, the personal information protection law, was like China's GDPR. And that had in it a provision at Article 38 that dealt specifically with when you could essentially send data outside of China. It basically said that you could do so if you had been certified by the relevant agency to allow you to do so. So you'd had a certification by the Cyberspace Administration, which is fair enough, and I'm not aware of that many people have actually got that. You could do it by using a standard contractual contract, a standard contractual clause, so a contract where you make sure that whoever you're transferring the data to has the same protections that you would expect and complies with the relevant Chinese laws. Or you could pass a security assessment by the Cyberspace Administration. And this was the thing that everyone was scared of. What would the security assessment look like? What would I need to do? And when would I need to do it? Now, in terms of the timeline, it was in June where we got the guidelines for certification. So you could essentially apply for certification and transfer data as you wish, provided you complied with the requirements of that certification. The standard contractual clauses came into force in June, so you could use those for small amounts of data. But the self-assessment comes into force on the 1st of September, just 2 days away at the time that I'm recording this. So what you need to know, and are you affected? Now, I'm going to use some slides for this one. I don't normally like using slides in presentations, but there's lots of numbers involved, and rather than me saying them very quickly and you not seeing them, I want to make sure you can see what I'm doing. So I'm going to go over to PowerPoint World by pressing this button now. So this is the rough timeline of Chinese data law. So 2017 we got the cybersecurity law, and then in 2021 we got the data security law, and of course the PIPL. And the PIPL is the one perhaps that affects most people overseas, because you will find that a lot of organizations, if they're doing business in China in any way, even if they're just marketing to China, may find they are collecting or transferring or having transferred to them Chinese personal data. Now, the PIPL I have talked about before at length, and a lot of the provisions were quite vague, particularly Article 38. This said that where an personal information processor needs to provide that information outside of China, it has to meet one of a number of conditions. It could either pass a security assessment organised by the State Cyberspace Administration, or it could be certified by the same administration, or it can conclude a standard contract, basically making sure that the data is being looked after. Now, what is coming into force now, and the thing that's scaring everyone, is this new security assessment, this requirement to essentially have the Cyberspace Administration of China decide whether or not you're allowed to do that cross-border data transfer. And it's not been clear until now what you need to do. It's also not been that clear whether you are required to do it. There's been lots of concern as to what sort of data is covered, how much data is covered. Well, here I can explain. So if you are a company or an organization or an individual or any entity really that exports important data abroad under the Chinese laws, and important data isn't very well defined. It's essentially something that could endanger national security, which of course is a bit of a moving target in China, then a security assessment is required. You have to do one. You've got no excuse, no matter how much, even if it was one data record of important data, you have to do a security assessment. If you're a critical information infrastructure operator, that's people running networks, keeping China going, but also as being seen as organizations who collect vast amounts of personal data, and you export that personal data, then you have to do another security assessment. It doesn't matter how much personal information you're actually transferring. The fact that you're a critical information infrastructure operator is enough. Now, those are unlikely to apply, I think, to most organizations operating in China, but they will apply to most when they're transferring data. However, if you're a personal information processor, a data controller essentially, that processes the information of more than 1 million individuals residing in China, so regardless of whether you're transferring the data, really, you need to do a security assessment. But the things that are most key is if you're processing information, you may not be doing it on a large scale, but you process the personal information of 100,000 or more individuals in China, or the sensitive personal information of more than 10,000 individuals since the January of the preceding year, the 1st of January, then you need to do that assessment. So you go back, you look at the preceding year. If you collected and transferred, or rather if you transferred 100,000 or more data records of individuals, or more than 10,000 data records of individuals in China, you are required to undergo this security assessment. Now, that may seem like a reasonably large number, but if you are collecting marketing information, which would just be personal information in China, then you'll probably quite quickly hit that 100,000 trigger. And similarly, if you have operations in China and have a lot of employees in China, you may easily have more than 10,000. You may then have more than 10,000 individual sensitive data. You may have, for example, some of their financial information. You may have their bank account details. You may have details of their family. You may even have, to a certain extent, their health records as part of HR. So you will have to do this. The question is, what do you have to do? Now, there's a few elements to it. Now, the first one is relatively straightforward in that you have to do a self-assessment. You have to look at what data you're collecting, what data you're transferring, critically where it's going to, what contractual clauses you have in place with the recipient so you can make sure that data gets the same protection wherever it's going. And you have to assess all of this, produce a report essentially that you will then generate, and that will then go to the Cyberspace Administration. Now, there are two limbs essentially to the Cyberspace Administration. There's the local provincial one, it's the one that's wherever you are operating, and then there's the big one, the big head honcho, the National Cyberspace Administration. And you will deal potentially with both. What will happen is initially you will submit your self-assessment application form and all the relevant documents to the provincial Cyberspace Administration. Then they will assess it. If necessary, they may say it's fine and off you go do the data transfer, but they may refer it up. It may go to the National Cyberspace Administration. They can go back and ask questions, ask for clarifications, ask more details about your operation, the data you're collecting, what that data is and where it's going. They may be particularly interested in where it's going and what it will be used for in the jurisdiction where it heads to. They almost or certainly be concerned about whether that data then will be transferred on to other jurisdictions. You need to go to that, and the Cyberspace Administration will either say, we've got more questions, you need to change some of your procedures. They may say it's fine, go ahead, or they may say no, this data transfer cannot take place at all. And if that happens, then frankly, you have to stop. Now, you may be thinking, this sounds horrendous. Why would I want to do this? I've been operating in China for ages and I was just transferring data without any concerns. However, it's part of the PIPL, and you may remember if you breach the Personal Information Protection Law, the PIPL, the penalties are quite high. Essentially, if you do something wrong, you can face a 50 million renminbi fine, or alternatively 5% of your previous year's annual global turnover, whichever is higher. Whoever's responsible, your data protection officer, may then face their own personal fine of 1 million renminbi. Or you may find that your business in China is completely shut down, you're suspended in China, so you can't operate anymore. Or there could be criminal sanctions, so it is a big deal. Now, here's a diagram pretty much setting out what you need to do in terms of the various steps. I'll go back to PowerPoint by pressing this button. So here are essentially the three main steps in diagram form. So if you are the data processor, you complete your self-assessment, you prepare your application materials, your declaration form, your own self-assessment report, and any associated legal documents. They will be, for example, the contracts you would have in place with the recipient of the data. You submit those to the local provincial cyberspace administration of China. They then decide whether to accept it within 7 working days and provide feedback. So they may say, fine, go ahead. But if not, it goes to the National Cyberspace Administration. They then will then take up to 45 days to decide whether or not you can go ahead. If you can't do the data transfer, they may suggest changes, other steps you put in place, or they will flat out reject. And essentially, if you want to have the issue re-evaluated, if they come back and say, no, you can't do this, and you essentially want to appeal, you can apply for a re-evaluation. You have 15 days to do this. But it is quite a drawn-out procedure, and it will slow things down. Of course, the problem is if it slows things down, the measures actually come into force in 2 days. Remember, the 1st of September, and you probably don't have 45 days. Do you immediately stop your data transfers now because this thing's coming into force and you haven't done a security assessment? Well, the answer to that is no. We've got a 6-month grace period from the 1st of September, which I think, if my knowledge of dates is correct, that will take you up to the end of March next year. So you've got some time to do it, but you need to start acting immediately. Now, some of these things I hope you've done already. If you are a large organization who've been operating in China for a long time, then I assume you will have some of these things in place. So you should have done, if you haven't done it by now, do it now, a data audit. What data are you collecting in China? Where is it going? And under what terms? What happens when it goes out of China? Who does it go to? If it travels further on, where does it go from there? What is it used for? These are all things you need in your self-assessment. These are all things that the Cyberspace Administration will ask for when it decides whether or not you can process the data. So do that now. The second thing you need to do is make sure you have a data protection someone, either a DPO, a data protection officer, or someone who can handle this, a point of contact for you and essentially for the Cyberspace Administration. This will be the person who will oversee your security assessment internally, will then deal with the relevant people within China. They're also, unfortunately, the people who are on the hook if something goes wrong. You may find that they face the 1 million fine if something does go wrong, but hey, that's an incentive to make sure nothing goes wrong. You need those two things in place now. Now, in terms of getting a DPO, a data protection officer in China, you can elect someone within your organization to do it. They should really be in China to do this. Or alternative, you can hire the services of an external DPO, but be warned, they do not come cheap. When they realize that they can face their own personal liability, they are obviously going to charge on that basis. But I do recommend you do that now. Now, a lot of the people who are watching this video will be thinking, well, Paul, I'm in Hong Kong. Hong Kong is part of China. Therefore, there is absolutely no need for me to worry about any of this. We'll just carry on as normal, taking all of our data from China, bringing it into Hong Kong, and we don't need to worry about this tricksy Cyberspace Administration requirements. We don't have to worry about a security assessment. We certainly didn't bother about self-certification, and we may even have been using the standard contractual clauses method, even though we collect too much data and transfer too much data. Well, that's not good enough. Quite frankly, what I think you really need to realize is that Hong Kong and China, they may be the same country, but they are definitely different jurisdictions. And at the moment, cross-border data transfer includes transfer from China to Hong Kong. You get that? If you're moving data from China, you move it to Hong Kong, it's a cross-border data transfer, and you're required to comply with all of the requirements of the Personal Information Protection Law. There's no sign that's changing anytime soon. It might. But in the meantime, you've got to prepare on the basis that it won't change. So there's lots of things we need to do. Now, 2 final points. First one, important data. We have a clear guideline of the number of personal information records you have to be collecting and processing and transferring to trigger a security assessment in the terms of personal data and sensitive personal data. So you've got the 10,000, the 100,000 threshold, and that will trigger your security assessment. But important data, even if it's one record, triggers a security assessment. And the definition of it, whilst I said, oh, it's stuff probably relating to national security or things that might be in the public interest, it is vague, and I think it's deliberately vague. Important data means whatever the Cyberspace Administration or whatever the Chinese government thinks it means, and it's anything that they feel essentially does have to be protected. If it's data that is considered sensitive to some degree to the Chinese authorities, it will be important data. So you can never be sure. If in doubt, do a cybersecurity assessment. Do a self-assessment, submit that to your provincial cyberspace administration, and then see what the result is, see what they say. They're actually there to help you. They're not there as some big enforcement body with a truncheon. At least maybe they are some of the time. And that's it. It's not a process that is welcomed because it is a bit of an administrative burden. It does take time. But at the same time, China's data laws, before we had these three new laws, pretty much were non-existent. They were split around lots of different laws. They weren't clear. Nobody really knew what they needed to do. Nobody really knew what was required to do. Most people didn't do anything. So I feel that for the protection of the data of Chinese individuals, this thing is important as much as it is with the GDPR or indeed any other data security law. I also think we may see similar provisions coming into Hong Kong. We are in the process of seeing amendments to our personal data privacy ordinance, which are long overdue, and they may well follow the procedures here. So you may find we have a cyberspace administration here in Hong Kong. Who knows? But hopefully that's clear. If you've got any questions or you need ideas or you're thinking, does this apply to me? By all means, get in touch. Contact me on LinkedIn or on YouTube, or indeed just drop me an email. I'm more than happy to answer any questions I can and point you in the right direction if you need some help. But in the meantime, that's it for the moment. You've got the time I'm about to put this video up. You've got 2 days to sort things out. Well, not really. You've got 6 months and 2 days. But make sure you do take this seriously if you're operating in any way that involves the collection, processing, and most importantly, transfer of Chinese data. That's it for the moment. I'll see you soon. Take care. Oh, and it was quite law heavy, so don't have nightmares.